right. Well, it's a pleasure to be with you here today. I had some travel difficulties coming in and arrived at the train station in Stone with no taxis, and I realized how un-English I was, as you could hear from my accent. I called up the taxi dispatch, and there was a proper English woman on the other end, and I couldn't understand a word she was saying. And here I'm Canadian. I always thought Canadians were cold Englishmen because we come from the same heritage, but I guess not. Nonetheless, I got the opportunity to have, for the first time in my life, a cookie crumble latte, which should be classified as a Class A narcotic. So if I start running around, you'll know why. But again, it really is a pleasure to be here with you today to discuss a very controversial and live issue, that being the place of freedom of conscience within the healthcare profession. Now, as a member of Christian Concern, we literally get calls every other week from nurses or doctors who are concerned because their line manager or their manager is telling them that they have to perform something that goes against their conscience. So this is an issue, despite the Abortion Act and the exemption therein, for many in the medical community, and I'll explain why through the course of this presentation. Now, prior to coming to England, I did practice religious liberty law throughout Europe, and I had the honor and the eye-opening experience of working with many people in the medical community who are going through very similar things. Eleanor Grimmark, for example, is a midwife in Sweden. Now, she is a Christian, and she had 2 previous jobs as a midwife. And the thing in Sweden is there is a serious shortage of midwives. Now, she had told me, and she's been open about this, that the reason she came into the profession was because, you know, she's a mother, she's a Christian, she loves the process of life and wanted to be a part of bringing children into the world. And in both of these instances of employment, she was told at the beginning, absolutely no issue, that the fact that you're pro-life, we won't ask you to perform abortions or participate, and it was settled. And in both cases, through ideology and through just the shifting of what the job process was, she was called upon to do so. And she recollected to them that when she had the job, when she was brought on for the job, she brought up the fact that she had this conscientious objection. And in both instances, they said, that's too bad, and goodbye. And it became quite a controversy. One of the reasons was because there is such a shortage of midwives. So for those who are really, pro-healthcare and saying this is about access to healthcare and we have to force physicians and nurses to participate so that people can have access, well, this is an instance where they were taking a midwife out of a system which was already grossly understaffed for the purpose of ideology. Now, I think the most egregious element of that case was that in the second instance, because the hospital was so desperate to have a qualified midwife, they had told her, we'll bring you back, but what we require is that you go through psychological training to learn the error of your ways, to learn that abortion is actually something that women need. And of course, she turned that down, and that case is now, I believe, going before the European Court of Human Rights, and she is happily in Norway practicing the profession she loves and not being asked to perform abortions for now. Norway is another country that's a little off the rails in this area. Now, another instance was the case of Dr. Bogdan Kazan. His case is a little more unusual because he comes from a pro-life country, a predominantly pro-life country, that being Poland. In 2014, Kazan, who is preeminent in his field, recognized throughout Poland as an expert, he is the head of, director of obstetrics and gynecology at the Holy Family Hospital in Warsaw, which is, I believe, the biggest hospital in Warsaw. He's got 40 years of experience, has published, I believe, over 100 peer-reviewed articles. So this is not a small-time player by any stretch of the imagination, and had been pro-life, and openly so, for a long, long time. Now, he had been called upon to perform abortion on a severely brain-damaged child, and he said he would not do it because it was the taking of life. And in Poland, there are exemptions for conscience, and this was purely political. So it was literally the mayor of Warsaw, who was a pro-abortionist, wanting to score points with her lobby, specifically asked that his contract be revoked. So this is again, it was big headlines in Poland, as you can imagine, when you have one of the leading doctors being fired by the mayor of the city for being pro-life. And thankfully, that went to court, and Dr. Khazan ended up winning and is still doing excellent work there in Warsaw, Poland. And the third case happened in Croatia, and this is another strange one, because Croatia is kind of a pro-life country. There are quite a few hospitals who have a position that they are not going to perform abortions. So entire hospitals and entire cities. Yet this was in Zagreb, and this young doctor was told either perform the abortion or resign. She resigned. What makes this an unusual case is that the Ministry of Health sued her for £100,000 to recoup the education expenses it took for her to become a doctor. That is currently still going through litigation. So, I mean, really what we're seeing here today is a very curious situation, a very curious point in history, because technology and science are developing at such a rate that it's getting more and more difficult for those who are for abortion to credibly say that this is not a child in the womb. The abortion industry, on top of that, has taken a lot of big hits publicly. We all know about the Planned Parenthood films in the United States. I'm sure all of you have seen them. We also know of Ashlyn Hubert and her case on gendercide here in the United Kingdom and the private prosecution that involved. And I believe Ashlyn is here speaking to you either later today or she already has spoken. And she's got a great testimony. I don't know if you've heard her speak before. So perhaps, like a wounded animal, the abortion industry has gone on the defensive, knowing that ideologically they're losing the battle. Within the spectrum of religious liberty, this is one of the areas where we are decisively taking ground. And so they are greatly on the defensive, and as they are in other areas of society, their defense is to shut down the debate altogether. It is to say, participate or get punished, celebrate or get punished. It's really a shocking turn of events. And, for example, we believe in, those in the pro-life community that abortion is the taking of innocent life. And so we tend to strongly advocate for rights of conscience. Whereas those who are staunchly anti-life or pro-abortion argue that medical staff should be compelled to perform abortions, as they argue, because it is a women's legal right to have that procedure. Now, as I mentioned, while one would think that this issue is solved here in the United Kingdom because of the exemption in the 1967 Abortion Act, two faithful pro-life midwives supported by SPUC showed us otherwise. Another recent example happened in the world of pharmacy. The General Pharmaceutical Council, also known as GPHC, its acronym, recently held an open consultation on religion, personal values, and belief, on changing its guidance on person-centered care to, in essence, require pharmacists to dispense all medications asked of them despite any conscientious objection. Now, on the 10th of April 2017, the GPHC issued a press release noting that they had revised the language despite a great outcry from the pharmacy community about rights of conscience, and they changed it to precisely that no longer would pharmacists be allowed to say no to providing certain medications. Now, only 2 months after, because of a strong pro-life lobby, they amended their guidance once again, this time to be pro-conscientious objection, and the current guidance now reads, and I quote, "Pharmacy professionals have the right to practice in line with their religion, personal values, and beliefs." Now, the consultation represents a realistic expression of just how contentious this issue is, the issue of conscience and how it is played out in the United Kingdom. Now, the issue of conscience flows into any number of other fields as well. We see, for example, arguments being used in the cases of cake bakers and florists that they should be forced to provide specific services for same-sex marriages. And now, keeping in mind what this is saying is there's a difference here between refusing to bake a cake for a same-sex wedding and denying a service to someone because of their sexual orientation. In none of these cases were any of the service providers accused of denying a service because of sexual orientation. It was always not wanting to participate in the solemnization of something that they determine to be sin. So the issue of conscience is really something that is spread across the entire scope of our culture today. So not to be overly political here, but I find it ironic that people who are demanding that our doctors and nurses and florists and bakers perform services against their conscience because it's, quote unquote, their job, but they are more than happy to call heroes those who are refusing services to people who hold beliefs they don't like pro-life people, for example. And just literally this week, we got at Christian Concern a phone call from a church that has had its contract revoked to use a local school in London, a local university in London, to have its Sunday morning services. Now, why was that? It's because someone from the university had been looking at the website, and lo and behold, they found in their statement of faith something about life. And it was their policy that they would not rent premises to anyone who was pro-life. Now, to me, that is an utter scandal. But it is the reality of what is happening out there. Now, conscience is it's one of those things that we all have one. But have you ever thought about how difficult it actually is to define what a conscience is? It's actually quite an intangible. So one very good definition I've come across is this. Conscience has to do with the inner forum of the human person and relates to the faculty of judging the moral quality of the human person and relates of his or her, let me start that again. Conscience has to do with the inner forum of the human person and relates to the faculty of judging the moral quality of his or her actions, and in particular with relation to one's perception and judgment of the moral qualities of their conduct. Now, the Catechism defines it thus. Conscience is a judgment of reason by which the human person recognizes the moral quality of a concrete act. The Catechism uses some very beautiful language, and I'd just like to quote it here because I think it sums up really well what is at stake here. It says that deep within his conscience, man discovers a law which he has not laid upon himself, but which he must obey. Its voice ever calling to him in love, and to do what is good and to avoid evil sounds in his heart at the right moment. For man has in his heart a law inscribed by God. His conscience is man's most secret core and his sanctuary. There he is alone with God, whose voice echoes in his depths. Now, Scripture tells us, St. Paul tells us in Romans 2, that while the Gentiles weren't given the law like the Jews were, they nonetheless had it written on their hearts. He notes that because of this, their conscience bears witness to their conflicting thoughts and either accuse them or excuse them of their actions. Now, ultimately, there is an interesting interplay in each of us between our will and our conscience. Not to get overly theological here, I don't know if it was St. Augustine or C.S. Lewis, but they talked about the nature of sin. Each of us has these dual natures of body and spirit, and despite the fact that our body leads us typically into choosing a sinful decision, it is our will which brings that into action, meaning that sin has its origins in spirit. It is a spiritual movement forward. Whatever the cause of sin, one thing we do know is that when we do something to offend our conscience, it is something we feel acutely. So much so that for many of us, at some point in our life, we do something that so offends our conscience that we carry that guilt with us for the rest of our lives. For some, it may be being unfaithful to a spouse. For others, it may be a criminal activity. For others, it may be having had an abortion or performing an abortion. Now, whatever the case, no matter if we have experienced this ourselves, I think each of us, whether we are on the left or the right of the ideological spectrum, know what it is to feel guilt. And therefore, we should know what it is to appreciate what following your conscience means. So this leads me back to the issue of medicine and science. The issue of conscience in the health community is greater than just the issue of abortion. Conscience issues are faced in any number of circumstances. Pharmacists who do not want to sell contraceptives or abortifacients, nurses who do not want to provide hormone therapy for those going through gender reassignment surgery, medical researchers who don't want to perform research on the human embryo. So, it includes a wide spectrum of activities. In other jurisdictions, it could be those not wanting to participate in assisted suicide. At this point, I want to make two things very clear. Anti-conscience advocates fundamentally make two arguments which are interrelated, and both of them are fallacious. The first is this. If a procedure is legal, medical staff must be willing to perform the procedure because they have a legal obligation to do so. This argument can also be defined as the following. Those who enter the medical profession are legally and professionally bound to perform the procedure which patients have a legal right to. Now, the second and related fallacious argument is that refusing to perform an abortion or other morally dubious procedure is denying, quote unquote, a patient access to a medical service to which they have a legal right. Now, I'll deal with both of these arguments in turn. The first argument, which states that if a procedure is legal, then medical staff have a legal and professional obligation to participate in it, it's false because it mischaracterizes the law. The law is never near, and as a lawyer who's been doing this for quite a long time, I can tell you the law is never as black and white as people make it out to be. Often there are laws in direct conflict with each other, and then the circumstances of how that outcome comes about will be determined by a balance of the competing rights. So in the instance of abortion, for example, so yes, it's true that within certain legal parameters, abortion is legal, and those parameters are obviously defined in the Abortion Act. Therefore, it's true that a woman has a legal right to, if she meets those circumstances, have an abortion. On the other hand, the right of medical staff to have an objection of conscience is also within the law. So there are competing rights there. And please don't mischaracterize me. I'm not saying that having a legal right to an abortion gives you a moral right to abortion. I'm not saying that at all. I think abortion is a grave sin. But this is something that anti-conscience advocates always point to. That's the legality aspect. So what they're saying basically is either you perform it or you're out. This is a professional obligation. You have a legal obligation to do it. It doesn't take into consideration the competing rights, that you have also the right to freedom of thought, conscience, and religion. So a similar argument that a procedure should be done because healthcare workers are employees and this is their job fails for the same reason. So just as the Abortion Act makes exemptions from certain instances of killing of the unborn child, so too does the law make legal exemptions for rights of conscience. Having a job as a doctor, a nurse, a midwife, a researcher does not mean that once you sign your contract, you sign away your legal rights. That is the very definition of tyranny. So let's talk about what rights we do have here in the United Kingdom when it comes to rights of conscience. So first we'll start with Article 9 of the European Convention of Human Rights. Now Article 9 has been transposed into the domestic legislation here vis-a-vis the Human Rights Act 1998. It states in the first clause, and I'll quote it here, that everyone has the right to freedom of thought, conscience, and religion. The second clause sets limitations to Article 9 by stating that freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society. And then it lists some of the legitimate aims which the state actors could use to limit freedom of religion. Now, in a landmark case called Ouida and others v. the United Kingdom, and some of you might know that, that's the British Airways cross case. Is it? Yeah, no. It was a big case. It was 4 cases combined. She was one of them, and she won her case. It was significant because it was the first time in European court history where the United Kingdom was found to be in violation of freedom of religion. But it had an interesting dissenting opinion in that case, which provides a very compelling conscience argument to me. So if you look at what is being protected by Article 9, it is 3 elements: freedom of thought, freedom of conscience, and freedom of religion. So the first element is freedom of thought. And I think scholars, legal scholars, judges will universally agree that we have an absolute right to think whatever we want. We don't yet live in an Orwellian society, although it seems we're heading in that direction. But for now, we have freedom of thought, absolutely. So then we skip over to the third element, and that is freedom of religion. Now, freedom of religion is mentioned specifically in the second clause of Article 9, where it talks about that freedom of religion and belief can be limited under these circumstances. So it specifically says freedom of religion and belief can be limited. So this brings us back to conscience, which is the second element. Conscience, like thought, is not enumerated in the second clause of Article 9. So two judges, those being the Russian judge, Judge Vuchnikovic, and the Italian judge, Judge De Cattiano, argued that because it wasn't part of Clause 2, that conscience is also an absolute right and should be respected like freedom of thought. So it's a very interesting textual argument, and I hope that it gains traction in cases to come, because these cases will be coming in the next 2 or 3 years, probably at light speed. So you'll be seeing quite a few of these cases coming before the court very soon. The European Court has already said in a Grand Chamber case, so the Grand Chamber is the highest chamber of the European Court. It's 17 judges sitting en banc, deciding issues that really matter. They set the law for all of the member states of the Council of Europe, including the United Kingdom. So in a case called Batayan versus Armenia, they had explicitly affirmed a right to conscience for sincerely held religious and moral beliefs as falling within the ambit of Article 9 of the Convention. So they did so based on 4 premises. The first premise is that where conscientious objection was not for a personal benefit, but was based on a sincerely held religious or philosophical belief, and it's important, it's also a philosophical belief. So it means a secular belief with regards to conscience is as equal as a religious belief to a right of conscience. That if you hold one of those beliefs, a system should be put in place by the state where violence is not done to that belief. So that's the Grand Chamber of the European Court saying that, look, conscience is a right, it has to be respected, a system should be put in place for any right of conscience. The second point it made was a refusal to allow conscientious objection failed to strike a proper balance between the interests of society as a whole and the fundamental rights of the individual. So as I said, just because you enter a profession, it doesn't mean that your fundamental rights are checked at the door. You carry those with you despite your profession. Third, democracy does not simply mean that the views of the minority will be subordinated to those of the majority. And I think it's funny to me in this day and age that the perception is Christians, pro-life people, that we are, the majority and we are creating a tyranny against this minority of people, when in reality they're screaming at the top of their lungs and silencing the debate. But really in that sense, because it is people with sincerely held religious beliefs and philosophical beliefs who are getting punished. They're losing their jobs, being fined, not being allowed to give lectures at certain universities. So this is a tyranny of, in that sense, the majority, and the court says that shouldn't be the case, that the minority person's rights shouldn't be subordinated to that of the cultural zeitgeist. And finally, they said that far from creating an inequality of discrimination in a democratic society, that provision of rights of conscience actually promote a stable form of pluralism and democratic values within a society where people are actually respecting and tolerating each other. So the United Nations Human Rights Committee, so that was the Strasbourg Court, which again has direct effect and will have direct effect in the United Kingdom even after Brexit, because it's a different institution. The Court of Justice in Luxembourg will no longer have effect, but the UK is still signed on to the Convention of Human Rights. So now a different institution, the United Nations, and the Human Rights Committee has similarly recognized a right of conscience. In General Comment 22, the committee has said that in relation to the International Covenant on Civil and Political Rights, that the covenant does not explicitly refer to a right of conscientious objection, but the committee believes that such a right can be derived from Article 18, which is Article 18 is the right of freedom of religion or belief. Now, domestically, beyond that, we still have the Equality Act. And the Equality Act prohibits forms of direct and indirect discrimination based on one of the protected characteristics, religion or belief. Now, again, importantly, belief can be a secular belief so long as it's cogent and seriously held. So this isn't a religious argument. This is an argument that if you have a right of conscience, whether it be for secular reasons, Christian reasons, any reason, it is a right that is to be respected and can't be discriminated against. And the Equality Act defines religion as any religious or philosophical belief, and a reference to belief includes a reference to a lack of belief. So a manifestation, again, of conscience, whether it be secular or Christian, is one that should be respected and can't be discriminated against. So any policy, even a blanket policy, where an employer, whether it be a hospital or otherwise, tells a medical professional that they have to perform something, that this is something for everyone to perform, is de facto indirect discrimination. The Equality Act defines indirect, and sorry to be all lawyerly on you, but I think it's important for you to know what the statutes say so that you can defend these arguments in public. The Equality Act says that a person, who they call A, discriminates another person, B, if A applies to B a provision, criterion, or practice which is discriminatory in relation to a relevant protected characteristic. So that means where the policy disproportionately hurts one of the protected characteristics, and here it would be a policy forcing someone with a conviction that abortion or any of these procedures is morally wrong to perform that procedure would be indirect discrimination, and you could bring a case under the Equality Act. So we have a lot of tools in our tool belt in that sense. We have the Convention, we have the Equality Act, we have the UN, so there are a series of legislations we could pull out to discuss this. Now, given that hospitals are also funded by the state, there's an additional public sector equality duty that's put on public bodies that they have to give a heightened response to protected characteristics. So in that sense, we have yet another supplemental argument saying that, look, hospitals are a public body. They need to be respecting rights of conscience because they fall within the spectrum of a protected characteristic, that being religion or belief. Now, despite that, despite the fact that we've got the Human Rights Act and the Equality Act, opponents of conscience are still saying, and you hear this quite frequently, and actually every person who calls us a Christian Concern and says that they're being forced to do something against their will is because Article 4 of the Abortion Act says that you have a right to opt out of abortion based on conscience. So they think that means that that's the only right of conscience in the entire law. That it means that any other form of conscientious objection would not be prohibited. And that assessment is false. It fails to take into consideration that there are lots of conscientious objection clauses within the medical profession, the pharmaceutical profession, and it fails to take into consideration all of the legislation I was speaking about for the past few minutes. So conscience clauses are in fact commonplace in the United Kingdom and cover numerous areas well beyond abortion where issues of conscience may be triggered. So for example, the issue of assisted suicide, even though it's not the law yet, it's an issue I work on frequently. It's amazing to me that they get unlimited kicks at the can, that anytime they file for a JR, it gets accepted. Parliament discusses it every few years. It's the only piece of legislation I know that really gets recycled over and over again. But the Royal Pharmaceutical Society has already drafted a conscience clause to defend themselves in case that becomes the law of the land, where it proposes an opt-in approach to conscience rather than opt-out approach. So that means you are already automatically given a right of conscience unless you opt out of that right of conscience. Section 38 of the 1990 Human Fertilization and Embryology Act provides a very robust right of conscience. The Human Fertilization and Embryology Authority's guidance is very clear and gives us a very good idea of exactly what that right of conscience spells out. The GMC, the General Medical Council, has provided similarly a right of conscience. It is one that I like less. That is an opt-in provision where you have to tell in advance any potential patient or employer that you have this right of conscience. So it's a less robust clause, but it's still there. But in any case, as instances of doctors, nurses, and anyone in the medical profession being punished for holding rights of conscience seem to be exploding at an exponential rate within Europe, the Council of Europe, the Parliamentary Assembly of the Council of Europe, passed a very important resolution just a few years ago. And it's one of my favorite resolutions, and I'll tell you why. It was brought up by an English woman, Christine McCafferty, who is very, very pro-abortion. And she thought, let's stick it to the pro-life community. We're going to put in an abortion that says that there's absolutely no rights of conscience. And lo and behold, it was completely flipped around. And it is now a very, very robust pro-conscience resolution which bears her name. So, you know, I'm Christian, but karma is, even though it's not a Christian. But anyways, I think it's worth reading some of what's in the resolution. So it says, and for those of you who are interested, it's Resolution 1763 of 2010. And it's often quoted in conscience cases, and it should be, because it's a very good resolution. And it says that no person, hospital, or institution shall be coerced, held liable, or discriminated against in any manner because of a refusal to perform, accommodate, assist, or submit to an abortion, the performance of a human miscarriage or euthanasia, or any act which could cause the death of a human fetus or embryo for any reason. The resolution further states that in view of member states' obligation to ensure access to unlawful medical care and to protect the right of health, as well as the obligation to ensure respect for the right to freedom of thought, conscience, and religion of healthcare providers, the Assembly invites the Council of Europe member states to develop comprehensive and clear regulations that define and regulate conscientious objection with regard to health and medical services, and which guarantees the right of conscientious objection in relation to participation in the medical procedure in question. So the Council of Europe recognizes in its resolution the twin issues at play here, those being respecting rights of conscience while at the same time allowing and ensuring access to healthcare. Now, interestingly, it does so without seeing a conflict of interest, and it errs on the side of conscience. And that is obviously not an approach we're seeing here in the UK, and one that I hope we will develop in years to come. So I think it's worth noting that opponents of conscience rights confuse the issues of legality and access. Their argument goes that because a procedure is legal, that we have an obligation to ensure access to that procedure. Now, just because something is legal doesn't mean someone should have an absolute right to access it. And I think if we look at what's happening in the United States right now with the gun debate, we see that as truth. The fact is there is a constitutional right to have and own a gun in the United States. Now, there is not an absolute right to have access to get guns. There's clearly restrictions on being able to get a gun, and they're wanting to put in more restrictions. So to say that something is legal or even a constitutional right does not give you complete access to getting that service or that thing. So furthermore, the question of what is and what is not legal is also one that we need to talk about. So when we talk about things like gender reassignment and the hormones that you can get for that and the treatment, when we talk about abortion, when we talk about any of this stuff, believe it or not, it's in a netherworld. It's neither completely legal or illegal. It's regulated. So we're not talking about giving complete access to something that's fully legal and a right here. It is something that's regulated, just like conscience, in a sense, is regulated. So what we're really speaking about here when they're talking about access is creating a bar to profession. What they wanted to do is keeping anyone who has a pro-life view outside of the profession. And that is probably the most egregious form of viewpoint discrimination you'll ever see. And it's also just bad policy. Is that what we really wanted to do, to keep anyone out who has a pro-life view out of the medical profession? You know, the reality is these are people who respect life. These are people who have gotten into the profession, many of them to help their proverbial neighbor. These are exactly the type of people we want in the profession. So patient care also matters. And statistics have shown that people who access health care, it matters to them who their doctor is, who their nurse is, who their pharmacist is. You know, if I am an expectant mother, and clearly I'm not an expectant mother, if I were an expectant mother, wouldn't you want a pro-life doctor? Someone who has your best interest and the interests of your child in mind? Would you really want someone who is virulently pro-abortion to be your doctor while you're seeking prenatal care? If you're elderly and living in another jurisdiction, do you want your doctor to be someone who is a pro-euthanasia, pro-assisted suicide advocate? That would scare me to death, you know?
So these are a little pun there. Well, but these are pragmatic things to think about. And just to close my lecture, I want to talk about one last thing, and that's a little bit about biology and procreation, and really how amazing the human body is. We look at all the different systems within our body. We have the respiratory system, which carries oxygen and removes carbon dioxide from the blood. We have the circulatory system, which transports dissolved gases and nutrients throughout the body. We have the digestive system. All of you just had lunch. You know what's happening in your body right now. I don't have to get into that. But all of these things work together for one sole purpose, and that is to keep you alive. But there is one system in our body which doesn't work on its own, and it requires biological complementarity. To have a child, you need the coming together of two different reproductive systems. And I think that's beautiful, not for the purpose of keeping you alive, but for the purpose of keeping the human race alive. And, we are biologically complementary, and I think that's beautiful. That's the way God created us. He said in Genesis 2:24 that a man shall leave his father and his mother, hold fast to his wife, and they should become one flesh. That doesn't mean that once you say I do, you somehow morph into the same person. That's not true. Your husband will still like watching football, and your wife will still like watching Downton Abbey or whatever women watch these days. Was that politically incorrect? I hope not. I've never seen Downton Abbey. But the fact is that it is through the process of procreation that you become one flesh. Each of us have 23 pairs of chromosomes. A chromosome is a thread-like structure of nucleic acids and protein found in the nucleus of most living cells, carrying all our genetic information. Now, each pair of chromosomes is represented by a mother and a father, by both parents. I think that's extraordinary. Most of the Y chromosomes are passed from the father to the son without changes, and the mother passes down her mitochondrial DNA to her child without recombination. But other than that, we really have a complete melding of our DNA and genetics. So I think it's incredibly beautiful that a child, in the truest sense, is the coming together of a mother and a father, sharing the DNA and genetic material of both parents is a true reflection of the marital bond. Now, amazingly, I just read this, and I'm a lawyer, I'm not a doctor, but it really tore on my heartstrings that a mother carries some of the fetal cells of her child for decades after birth. And some of those cells go into her brain, combine with her brain cells, some of those with her blood, and they find that in various ways. So if you are a son, some of your tissues could be discovered in your mom's bloodstream, for example. So it's beautiful to me that bond is there biologically for the rest of your mother's life. And Mother's Day is coming up, so just thank her for carrying you along with her every day of her life. It's a beautiful thing. I'll just say a few more things. That from the moment of conception, your sex is determined by the chromosomes you have, if it's XX or XY. As early as 8 weeks gestation, endogenously produced sex hormones cause prenatal brain imprinting that ultimately influences postnatal behavior. More than 20% of your genes in the human genome are specific to one of the genders or the other. Up to 6,500 genes in any given cell are sex differentiated. So that means that in the reproductive cells primarily, that's where we see the highest levels of differentiation, they are specifically male differentiated or female differentiated. That's why female breast tissue allow for lactation, whereas men's don't. Men develop different muscle because of that differentiation than women do. Women develop fat differently than men do. So all of these things are determined from the moment of conception. Again, I think looking at all of this, it's no wonder why geneticists and biologists so often become Christians at some point in their life, because it is a modern day miracle. It is God's design for procreation, for marriage. All of this comes together, all of it. If you're pro-life, you've got to be pro-family. They work together. It's God's design for marriage and life. And just always keep in mind, please, that life is beautiful. It's complex. It's a gift from our Creator. What we're fighting for here, all of us in this room, is that gift. And the life of the unborn child is very, very worthy. God has filled you all with the grace, the talent, and the desire to protect that life. You wouldn't be here otherwise. And I think really any number of you could be the next William Wilberforce. And I think it's a powerful thing to think about. In the same way, I hope that at some point in the future, and I pray that it'll be in my lifetime, but I think that one day we'll look back on abortion as a horror, like we do slavery. Abortions won't be performed not because they're illegal, but because we see them for what they really are, and that's institutionalized murder. But fighting for these rights of conscience is part of that battlefield. We need nurses and doctors, midwives and researchers in the field who are pro-life and who are standing strong. So I ask you, let's keep those faithful in your prayers. Thank you so much.
So thank you so much to Mr. Kiska for that talk. I think that's something that's also relevant for us being young people. I mean, especially when I think of like the Scottish group for us, like that's a big thing right now on campus. Like, do you have the right to conscience, and can you be pro-life, and is that all right to have that opinion? So thank you so much. And I watched Downton Abbey, so that was fine to comment on that. We're going to have 10 minutes of question time right now. So if anyone has any questions, now's your time.
Thank you very much for that talk. Can we derive any assistance from the Nuremberg jurisprudence? What I really mean is this, that it seems to me that the real principle, or the two principles established at Nuremberg, were first of all that positive national law can be contingent. So in that particular case, Hitler's racial laws didn't mean that people had a right to the things that those laws provided, or lost the rights that they should have had it not been for those laws. And the second point, it seems to me, that Nuremberg provides is that there's actually a duty to follow your conscience against the law sometimes. Can we use Nuremberg to help us?
It's an interesting question and a fascinating intellectual exercise in that sense. And I think looking at Nuremberg, the fruit of Nuremberg was the Convention of Human Rights. It was the Universal Declaration of Human Rights. It was a time when the world got together and said enough is enough. We need to take tyranny away from governments and imbue individuals with the human rights that belong to them. One of the problems that we are facing is that we have quite significantly stepped away from natural law jurisprudence to positivism. I live near Austria. Hans Kelsen is kind of the leading father of positivism, so you could blame the Austrians for that. But what they're saying is that if a law is promulgated by an authority which has a lawful duty to be an authority, then you have to follow that law. And that's where we're seeing all of this garbage about you have to follow the law. You know, that comes from positivism. The problem with legal positivism is that what they're saying is that, I mean, they cannot say that Nuremberg was wrong, because that was a legitimate government at the time. What they were doing was they were empowered to do. So I think we do need to somehow grasp back natural law theory. Specifically to that question, it's difficult in this day and age, especially with cost orders and vexatious litigation, to argue Nuremberg. It can be part of an argument, certainly, but it has to be contingent on all of these other pieces of legislation. I think the Nuremberg argument is one which is great for scholarly articles, to build up. I think one of the things that we see when we're changing laws, you need to build up to that. So publishing on it, getting people talking about it, and then those arguments being made in court is a way to do it. Right now, if we were to go before a court and say rights of conscience are based on Nuremberg and that alone, it wouldn't be a winning argument. But if you said it as part of a greater package of arguments, I think that would be effective.
As a nurse, I've been following the situation in Canada with legalized euthanasia. Are there any insights you could tell us, like how is this country reacting to, it seems there's quite an aftermath of like doctors not wanting to participate, and I just thought that'd be interesting.
Yeah. I have not lived in Canada for quite a long time, but I do keep up with what's happening there, and I can say that it's a strange country. Well, we're very polite people. We're very polite. But the reality is there's a huge disjunction between what the government is doing and what regular people think. So I went to a church which was in a town with one cafe and one gas station and 7 churches that were all full. That to me is what a regular Canadian is like. So unfortunately we had like what we have in too much of Western Europe is there was a liberal elite which was setting these crazy laws, and now people are suffering because they didn't know what they were signing up for. So my hope is there are some pretty good organizations in Canada who are fighting on these issues. And again, legal associations, lawyers, even the handful of politicians who really believe in this stuff, they can't do it alone. What we're needing is groups like you. We're needing large groups of people who are standing up for those rights. We're needing doctors and nurses to stand up for themselves and not worry about their professional credentials or their reputation. It's only in fighting this and publicizing it, because I think everyone understands what it means to go against your conscience. And if you're able to explain that narrative compassionately, people will believe it and laws will change. So I do believe in my heart of hearts that abortion is on its way out. The times are changing, and that this is a last-ditch effort from pro-abortionists to get their ground back by silencing the debate and forcing people to perform abortions. In the US, we're seeing at a record level clinics closing. I think that's a wonderful thing. And that's another reason why they're fighting so hard to force people to do this. But.
Hi, Roger. Just 2 quick questions. One's legal, one's political. In terms of the margin of appreciation, how wide is it in this subject matter? And political question, the Baroness O'Loan bill that's going through, do you know about that?
No.
Baroness O'Loan's proposed conscientious objection bill within the House of Lords, which I doubt will actually get through, but because the pro-abortion lobby is so strong,
Yeah.
and it's to see how we could propose such legislation and make sure that we can kind of get wider consensus with those that might not necessarily agree with us on the abortion debate, but the fundamental right to conscientious objection.
Yeah. Well, this is a hard question. The first part of the question is hard to answer because it's, the Wizard of Oz, you pull away the curtain and then you realize that it's not what it was. And then the legal profession, unfortunately, is not what one would think it is. It is filled with a lot of ideological judges who are making up the law as they go and doing all sorts of legal acrobatics to get the judgments they want. And so sadly, the margin of appreciation, it's a legal doctrine that is used by the European Court of Human Rights that says that a member state has a certain level of discretion to define what the law is within their own country, because 7 judges, or if it's the Grand Chamber, 17 judges sitting in Strasbourg can't appreciate what's actually happening on the ground in the member state. So it's a nice thought that gives respect to subsidiarity, but the reality is it's very subjective. So the margin of appreciation is really defined by that individual chamber at the time. And with conscience, they're always balancing against competing rights. So in OIDA, they actually said it was a wide margin. If that means that if we had the same case in Norway, but it was flipped around and it was a pro-Christian type instance, would they rule the same? So again, margin of appreciation is just super subjective, and there are lots of law review articles about it. But having someone who, I've been before the court, I think 40 times, and I just say it's really a flip of the coin, unfortunately. With regard to rights of conscience and the bill, I pray that it passes. I think one of the ways we're going to secure it is through the European Court of Human Rights. And then that will become the law of Europe. At least I'm hoping. And you see that there's an advantage to having these cases before the High Court, because you can get really sweeping legislation. And the judiciary is kind of an unfair, you have your checks and balances. The judiciary is really an unfair check because they kind of get last say. And sometimes if they declare it to be a constitutional right, not even Parliament could really tinker with it. So really, all of you, become lawyers, please become good lawyers, and let's change those laws.
Hi. This might be a bit of a silly question, but I was thinking of couple of cases I heard about where a woman decided to have an abortion, but then her boyfriend or her husband didn't want her to, so then he tried to plead for custody rights to the unborn child, but it was refused because the judge decided that the child was part of her body and therefore it was her decision. But we know that a child's actually made up some of the cells, genetically part of it's her, part of it's him. But also know it's very hard to get a woman to decide to give birth if she really doesn't want to.
Yeah.
So I was wondering, is that like an impossible case to solve, or is there a solution?
The solution is we have to get there incrementally. Sadly, a lot of legislatures internationally, whether they be here or abroad, and a lot of courts are thinking the same way. There's a lot of instances where you don't even have to get consent from your husband to get an abortion. You don't have to get consent from your parents if you're under the age of 18. That is where the pro-abortion lobby has been very successful, by keeping third parties out, by saying that this is an obstruction to the right to choice. And reality, it's, real choice is something that, let's sit down and talk about this, get all the information we need, have all the parties at play, have all the stakeholders, like the father, involved. That is real choice. And what we're seeing is quite the opposite. We're seeing now all over the UK these consultations about so-called buffer zones around abortion clinics, where women can't even be exposed to the pro-life message as an attempt to save the child. And as someone who for quite a while took part in that type of work, sidewalk counseling, I think it's a disgrace, and it's highly political, and it is on us, as most of this is, to be active to ensure that these rights be maintained robustly, and for us to incrementally move the ball forward. I don't think there's going to be an instance of us just getting a home run. I know that's an American thing, but at one time it's going to be incremental. And so winning back some of that jurisprudence is key, but sadly that is the state of the law right now.
Yeah, this is the last question.
What a responsibility. Thank you so much. I learned a lot today, so thank you. I am not sure that whether this is an intellectual exercise, but I was wondering whether not acknowledging the personhood of a baby that isn't born yet, and considering that abortion isn't seen as morally problematic by so many people, why, or whether, is there anyone who is trying to make infanticide legal on the grounds that that also isn't really a person yet? Because there isn't that great a difference between, a 7-month and 8-month child inside the womb and a newborn. So I'd like to ask if, like, intellectually, academically, or like in the legal sphere, is this being tried? Is there anyone who's standing for this?
Yeah. There haven't been court cases yet. It's still considered murder. Whereas late-term abortion, no matter if it's even an hour before natural birth, is still, in a lot of jurisdictions, considered an abortion, even where that child is born breathing. So I think that it is an artificial distinction. First of all, I think we have to recognize that before birth, after birth, it's a child, and that argument gets stronger even to those who are not pro-life the closer you get to birth. So the cases haven't been there, but certainly philosophically, guys like Peter Sanger in Princeton, he's the founder, he's often credited as the founder of the animal rights movement, has made the claim that animals should have more rights, especially infant animals, than human babies, because human babies can't take care of themselves. And in that sense, they're not yet fully human. And he's a chaired professor at Princeton. So that argument is becoming more and more popular, and it is only to our benefit, because I think it shows the insanity of those on that side. But yeah, before the courts, no way. But in academia, yeah. I mean, they're crazy in academia. I can't believe that's the last statement I'm going to make before you, but I thank you for your time.